Singapore plans to examine its intellectual property regimes to keep pace with the rise of artificial intelligence. It is seeking public views on key copyright and patent issues, including who should be recognized as the creator of AI-assisted work. Law Minister Edwin Tong also urges firms to make intangible assets a core part of their business strategy. Nadira Zaidi has more.
There's more to this cup than just coffee. The process behind brewing this drink is a closely guarded secret. For this local startup, protecting its intellectual property goes beyond how its coffee is made. Even the data generated by its vending machine can be deemed as a valuable intangible asset.
We have currently more than 170 machines island-wide in Singapore. And every of these machines is generating telemetry data. So sales data, it is telling us whether the machine has errors, has fault, technical faults, right? So all of this data goes back and help us with our operations, our maintenance, right? The technical work, as well as our sales aspect of our business.
At the opening of Singapore IP Week, Law Minister Edwin Tong says intangible assets like software and data are increasingly key to staying competitive. He added that artificial intelligence has dramatically changed where businesses derive their value.
If anyone can generate a good advertisement in seconds, the brand behind it may then matter more than the advertisements around it. If thousands of product designs can be generated overnight, the advantage may lie less in generating them and more in knowing with data what your consumers want, know-how and networks then to bring it to the market.
And that's why Singapore plans to strengthen its intellectual property framework. It's to help businesses here and abroad find value in its assets through new guidelines and programs. It is also seeking public views on how AI affects patent and copyright issues. For example, whether copyrighted works can legally be used to train AI.
When content becomes abundant, true human ingenuity becomes more, not less, invaluable. IP will increasingly be about not just protecting what is created, but also establishing who created it. And I think this is a new question or a new dimension that we should think about carefully.
Singapore will also deepen its international partnerships to develop a common language around intangible value. This could make it easier for these assets to be invested in and transacted across borders.
The World Intellectual Property Organization plans to step up efforts to make intellectual property more widely understood and recognized. It says IP should no longer be seen as a technical legal matter. The agency also wants to play a bigger role in supporting global dialogue to address complex challenges.
IP must continue being a way for us to collaborate and cooperate, even in a world where political divide and conflict is becoming more common. I've often said that invention is a solo endeavor, but IP is a team sport. And almost every device that we use, let's take the smartphone as an example, embeds innovations and inventions that cut across hundreds, if not thousands of enterprises, inventors and innovators.
For more on how AI will make an impact on copyrights and patents, we speak to Chief Executive of the Intellectual Property Office of Singapore, Tan Kong Hui. Kong Hui, let's begin by asking this question. If AI is used in coming up with an invention, who actually gets to call themselves the inventor? And looking at our current patent rules, does it still apply in situations like this?
That is a great question, Paul. And many such questions have appeared in the world since generative AI was introduced about 3 years ago. So that is why we made this year's Singapore IP Week have a theme around AI. And, the conference started today. It had more than 1,500 participants and coming from more than 50 countries. Now, going back to your question around inventorship and who are the creators. So our regime is one that recognizes, rewards, and incentivizes human creativity and inventiveness. Although AI is a very sophisticated tool for creating things, for inventing things, today, to get protection, we still require a human creator as well as a human inventor.
Now, we all know that AI can churn out huge amounts of technical information. Could that make it harder to decide whether invention is actually new?
Yeah, another great question. So, whether a piece of information is created by AI or whether that is created by a human being, actually, in the course of patent examination, it doesn't really matter. Our patent examiners will look at the relevance of that piece of information in assessing whether a patent can be granted or not, right? And IPOS has the hallmark for producing quality examinations, and we hope to continue to uphold that quality. Now, the real issue is with AI generating a lot of information, that amount of work to look through that information increases, and that can drag down the efficiency of IP offices. So in the same way that technology has helped us generate more information, I think it can also aid us in producing better search tools, better tools for analysis. So I think in a sense, I think in a very near future, this will not be a problem.
Now, to understand this clearer, if I give AI, say, a prompt and then refine what it produces, at what point can I call that work mine, and how much of the creative input needs to come from me for copyright to be applied here?
Yeah, so the work can potentially be called yours, but it does depend on whether there is sufficient engagement of the human intellect. So let me give you an example here. So if a piece of work, you've just given it one or two prompts and it's mostly generated by AI, that is unlikely to be protected, and it probably cannot be called yours, right? But if you have done a lot of work to shape the output, to shape the outcome of the work, given a lot of creative inputs to the AI engine, the chances for protection is higher. Now, ultimately, whether it meets the measure of having crossed that line for protection, that is for our courts to assess. We have engaged with many creators. Some of it is through the Visual Audio Creative Content Professional Association. And we know that creators are struggling with this exact question. And this is why IPOS has published AI and IP explainers. It's on our website to help people understand. We give them practical tips around how they can document the human contribution in their work, so that when it comes to the crunch, they have proof that it was a human that contributed sufficiently to the piece of work.
Now, speaking of creators, a big concern for creators is those who use their work to train AI. How do we protect their rights without making it difficult or costly for AI companies to innovate?
Yeah. I'm glad to say that the Singapore regime today has carefully balanced the needs and of both stakeholders groups. Right? On one hand, the innovators, the tech companies, they today have legal clarity on how they can use copyrighted works for purposes of text and data mining. On the other hand, our laws also protect the interests of our copyright holders. Right, and we do that through safeguards. An example of this safeguard would be that the innovators will have to lawfully access the data or the copyrighted works. And we do this through a piece of exception in our copyright law, and it's called the computational data analysis exception. So with this exception, actually, it gives a lot of clarity to both sides, and it balances the interests of both parties.
Now, for the everyday users of AI tools, like myself, how do we know that if we're accidentally infringing on someone else's copyright? What can people in business perhaps do to protect themselves?
Yeah, I think the first step is exactly what you have done, which is having some awareness that these AI tools, while they are powerful, you can be more prone to infringing copyright when you use these tools to generate images and works. So then the next is about taking some practical steps. And that is really about checking the output that you get from these AI applications, and then making sure that they have not infringed on some other works. So there are, in fact, already many digital tools available to do that. One of them would be a reverse image search tool. You can use a reverse image search tool to verify if there are similarities with existing works. And I think this is a really important step to take. especially if you are trying to use these AI-generated output for commercial purposes.
Now, a quick question, our last question actually. Looking at the bigger picture, how does Singapore need to get right if it wants to be a trusted IP hub in the AI era?
I think we are already on track on becoming a leading IP hub for the AI economy. We have many strong fundamentals today. In fact, the value propositions that make us a leading hub today, which is trust, quality, efficient examination, a very capable IP services sector that can serve the most sophisticated needs of MNCs and companies. I think these are value propositions that remain valid going into the future as well. So I have a lot of confidence that we can remain a trusted IP hub in the AI economy looking into the future.
Well, thank you so much for sharing your insights with us on this matter. We've been speaking to the Chief Executive of IPOS, Tan Kong Hui. Thank you.